For the session, stressed assets resolution, impediments, and the road ahead. We have with us our speaker, Mr. Anshul Jain. This is the webinar number 2 in the series Amity PricewaterhouseCoopers series. Before I hand over the session to Mr. Jain, I will take you through his quick profile and introduce you to him. Anshul Jain is a partner with PwC India and has over 17 years of experience in corporate structuring, mergers and acquisition, PE, and regulatory space. His focus has mainly been in the areas of transaction advisory, regulatory, and general corporate advisory, corporate structuring, and mergers and acquisitions across various sectors, which encompasses financial and strategic investments, acquisitions, mergers, spin-offs, joint ventures, foreign collaborations, and various other types of commercial contracts. He has also been leading the advisory in the space of stamp duty laws and its implications in the large M&A and restructuring transactions. He has also recently been involved in large bankruptcy, stressed asset acquisition transactions as an advisor to the creditors, resolution professional, as well as acquirers. He has led certain large acquisition transactions in the infrastructure, power, and textile sector under the current IBC regime in India and regularly advises domestic and foreign clients in acquisitions of such companies under financial stress and financial institutions in dealing with stressed assets. He has also been advising various ministries and government departments in the area of corporate laws, insolvency and bankruptcy code, stamp duty, etc. He has also advised clients in various shareholder and management disputes and have represented them in NCLT and high courts in matters related to oppression and mismanagement, hostile takeover, squeeze outs, acquisition of assets through IBC, etc. So it is our pleasure, Mr. Jain, to have you over here in this webinar 2 of the series Amity PwC. I throw this webinar open to you for your presentation and your talk.
Thank you, Gaurav. Good morning, everyone. Thank you, Gaurav, for the introduction. Without much ado, I'll try and jump quickly on the presentation. First of all, my apologies, my video is not on. There are some bandwidth issues and which I'm facing. So in order to be seamless in the presentation, we have decided to keep the video off and we'll run the presentation like this. The way I have prepared this presentation and wanted to take all of you through this the slide deck is while Gaurav has explained the whole concept of stressed assets and the impediments that resolution applicants or the potential acquirers face in resolving the stressed assets, I think I have tried to keep it very simple and very basic in terms of the issues that the prospective acquirers face and what all way forwards or nuances that are there in the processes and the possible solutions that we have adopted out of our experiences in handling such matters in past. We have done, IBC is a new law. This says it is only 3 years that this law has come in, and there are almost 30 plus amendments that have already happened in this law, primarily to help the lenders or the resolution applicants in taking the best advantage of this law and help them in acquiring companies under this process. The whole concept of IBC, as we all know, is to try and resolve the NPA issues or the financial stress in the industry. There have been a large amount of NPAs in the companies who have not been able to repay their lenders, and there were many mechanisms or legal avenues in past which were used by banks and by other creditors to recover their money. But unfortunately, either they were time-consuming processes or they were not very efficient in achieving the resolution or recovery. At most, they were ended up as a recovery law and not a resolution law. And that is where the need of IBC was felt, where the regulator felt that it is high time we should try and resolve companies instead of only using the law to recover the money. The whole thesis of IBC is to help companies revive back, see if the resolution of a issue can be done through the IBC process. In most of the cases, the issue is financial stress in the company, but there can be challenges where even the companies are not either being professionally managed, or there are issues with the promoter, and that is where the whole amount of stakeholders which are attached to the company are facing a huge brunt against this entire issue. IBC helps them in resolving these and addressing these issues. IBC also helps finding a new buyer for the company, which helps the company revive back and stand on its own feet, not only for the financial creditors or the banks as we normally know them, but also for all the stakeholders who are attached to this asset. This is the broad division of the presentation that I've done, where I'll first give you a brief introduction on the IBC and what are the key provisions that needs to be kept in mind. I'll try and keep this session without using jargons, legal jargons or technical jargons. I'll try and be as simple in my language as possible, and would also try and present this entire presentation in a very laymanish language, so that all of you can easily understand IBC and how this IBC law can be used for, let's say, acquirers or lenders in resolving the issues. There is one important element in an IBC, which is the resolution professional, which is, as we normally know them as administrators in the US and the UK laws. The administrator's role is that the moment a company goes into insolvency, a resolution professional steps in as an interim CEO or interim managing director of the company, and with the sole purpose to run the company for during the insolvency process and try and find an acquirer or a buyer who will step in and resolve the company and hand over the company to the said buyer. This is the whole process of this is an important piece in the entire IBC process. And how then IBC is used as a mode of acquisition, while the idea is novel, but at the end of the day, it is the incoming buyer who has to step in and find solutions in reviving the company. So how is IBC helping the RAs? That is what the genesis or underlying thesis of my today's presentations is. And then I will also briefly touch upon some of the judicial precedents which helped us shape up the IBC law in the shape and manner as we know it today, and some recent amendments that came in specifically vis-a-vis COVID times, and how IBC is helping all of us during COVID times, and how the regulator has relaxed some of these provisions. From an introductory paragraph, as I said, the whole insolvency process as pre-IBC was not something which was very structured. There were many laws in past, as way back as 1993, where recovery was the underlying objective. But unfortunately, either because of the court processes, a lot of time was taken by the companies in resolving the entire process. The bankers were not getting adequate recoveries, and the whole time process which was required in various previous laws was killing the whole intent of this process. That is where the regulator felt the need to come out with one particular code, which will help companies address all their issues only under one particular act and not under multiple acts. They also felt the need of making this process a time-bound process, and that is why there is an upper limit of 330 days, which has been prescribed under IBC, while there is a Supreme Court judgment which says that 330 days violate the fundamental principle, the Article 14 of right to do business. But what it also says, the same judgment also goes on to say that because the underlying objective of recovery under this law is to make it a time-bound process, unless there is an absolute requirement to extend the timeline beyond 330 days, the parties involved in the process, including NCLTs, the National Company Law Tribunal, who are the nodal judicial bodies overseeing the entire process, NCLTs should try and figure out the way and mechanism to wrap everything up within 330 days, and only on an exceptional basis they will allow going beyond 330 days. So to that extent, there is a lot of certainty that has been brought in under the IBC process. Here the creditor is a king. So the creditor is the one who takes up, who's the decision maker in the entire process. It is not the company which is insolvent, not the promoters of the company. They are no more running the company once the company is admitted, and it is the creditors of the company, or we call it committee of creditors, COC, which steps in as a board of director of the company once the company is admitted under IBC, and they take all the decisions vis-a-vis running of the company, as well as in terms of helping sell the companies to the prospective resolution applicants. This slide gives you a bird's eye view on various laws that were there pre-IBC, which helped companies into at various occasions to help them recover their money. It started in 1985, but SICA unfortunately was not very well adopted, and that is when in 1993, where the whole process of recovery was brought in under the DRT Act, and a tribunal was created, which is the Debt Recovery Tribunal. That is where even SICA also got teeth, and the BIFOR also tried resolving companies through 1993. So that is where we say 1993 is the timeline from which the whole insolvency processes under at least the regulatory regime of the country started. There have been multiple other schemes and acts and regulations that have come out by RBI as well as by the regulators of the country. RBI has come out with various mechanisms like corporate debt restructuring, or the RBI framework for revitalizing distressed assets, or the joint lender forum, or the SDR mechanisms, or the S4A mechanisms. Unfortunately, in all those regulations or the schemes that RBI and the other regulators came out, the underlying theme was, one, there was no timeline within which these processes had to be complied with or to be followed. Second, there were no teeth that the regulator or the overseeing body had against the erring promoters or against the defaulting companies. And that is why the whole challenge kept on seeding, that companies who did avail, let's say, a CDR or a JLF or a S4A mechanisms, they used it every time there was a default, and they still came back and acquired the company by the CDR mechanisms. Just to give you a context, one of the largest companies, which was the first one to resolve under the current IBC process, that company was had run through the CDR mechanism 5 times before it finally went into IBC. And despite of the CDR mechanism being implemented by RBI, where an oversight body was there to oversee the whole operations 5 times in a row, still they were not able to resolve or revive the company, and the company ended up finally into insolvency. And now the company has been acquired by one of the largest steel makers of the country and is running fine for last 2.5 years. So that is the impact that IBC brings. IBC helps resolve all the issues that were there from 1985 till 2016 laws, and helps take all good points of all these laws and consolidate under one code. This is one slide which gives you a bird's eye view of recoveries that have happened till March 2020. The number of cases that have been resolved are 221. While there is a lot many other cases which are still pending either with NCLT or at different stages of resolution, but resolving 221 cases also is a Herculean task. And when I say these 221 cases, the amount which is involved in these 221 cases is way higher than what all the mechanisms from 1985 till 2016 were able to achieve on a consolidated basis. The settlement of claims that have happened is more than 3,84,000 crores, if you see the slide. And the overall recovery that has happened is close to 46% against erstwhile regulations, where the recovery was less than 1%. So this is the benefit that the IBC does bring in. While there are many comments on how the balance 55% or 54% has been eroded, yes, there is always always a means and a way to look at glass half full and a glass half empty. But I think from where we started, from 1% or under 1% recovery, the recovery right now is 46%, which is really commendable. And the banks have been able to recover this entire 1,76,000 crores back in their coffers, and they have received the money. It's not something which is deferred or will be received in some or the other fashion in many years to come. It is already recovered and is now recirculated within the system. So that's the good advantage of using IBC as a recovery mechanism. The progress made, this presentation gives you a bird's eye view on various sectors which are into insolvency. It gives you, if you see, it also helps you understand the quarterly trends of the cases which are admitted. So if you see just before COVID, in the previous quarter, there is a large amount of cases that have been admitted by the NCLTs. And if you see, the largest amount of cases that have been admitted belongs to the real estate or the ancillary activities. The manufacturing activity, on the other hand, or hotels, restaurants, etc., all the other sectors represent a very low number in terms of matters that have been resolved. But if you see a comparative advantage of these cases, wherever there is a manufacturing company or there is an underlying asset in the company, the percentage of recovery, percentage of closure that has happened is higher than compared to, let's say, services industry, where you do not have any underlying asset, and it is either the promoter or the senior management who's running the company, and therefore there is no real value in the company itself. So that is the learning that we have done from whatever our experience in the last 2.5 years of IBC has been. These are some of the large transactions that have happened that have been concluded, and just giving you a perspective on what are the largest companies. For example, Bhushan Steel, where the realization was 63%, and it was acquired by Tata Steel. The next one is SR Steel. You must have read it across all newspapers. This has been going on for almost a year and a half. Since SR got admitted, and ArcelorMittal finally, after almost a decade, managed to enter India by way of acquiring SR Steel, and the amount of recovery in that is phenomenal. It's 82% plus. And if you add the claims of, let's say, operational creditors or business creditors, the recovery is actually more than 90% in this matter. So if you see all these cases, NBCC, for example, there is 100% recovery. This is JP Infratech. You've already heard a lot about it. The home buyers issue. There are more than 2,000 home buyers in JP. They all are not getting developed by NBCC. So they by the home buyers. That's why the amount of recovery is almost in this particular process. And matters, the amount of recovery is very low. For an average, if you see, the largest cases of the country got resolved through IBC, and the amount of recovery that the lenders and other creditors got in the entire process, and now the companies are well up and running and are being revived, which is not only helping the lenders and the shareholders, but also helping other stakeholders attached to these. Some of the key provisions that one needs to keep in mind, and as I promised, I try and keep it as laymanish as possible. This chart gives you a perspective of how the insolvency proceedings can be triggered. This can be triggered as per this code. This can be triggered against corporates as well as individuals and partnership firms. As of now, individuals and partnership firms, the law has not yet been notified, or the relevant sections have not yet been notified. Right now, we are only using IBC for resolution of insolvency for the corporates. The simple process is, if the corporate finds a resolution within the period of 330 days, then it is resolved. Otherwise, if they are not able to find a resolution, then it goes for liquidation. If, on the other hand, for individuals, the only slight difference here is that for personal guarantors who have given guarantees for the claims or loans taken by corporates, at least for those individuals, the insolvency has already been notified. So if a promoter has given a personal guarantee to secure the loan of a company, and the company goes into insolvency, the lenders have the right to invoke insolvency or bankruptcy against that individual promoter also. But apart from that, on a standalone basis, if an individual or a partnership firm or an LLP today wants to invoke insolvency or put themselves into a bankruptcy process, as of now, they cannot use insolvency law. The laws that they can use is either RFC or DRT. And once it's notified, then the IDC can also be used to avail of it. This is the British process of insolvency, where a corporate debt or company, as we call it, will push into NCLT. So an application by the insolvency will be filed with the NCLT, National Company Law Tribunal, which is the nodal judiciary body overseeing the IBC process. NCLT either rejects the application or accepts the application. So if the application is rejected, you're back to square one. I mean, the company is out of the clutches of insolvency. A classic example, Flipkart. Flipkart was applicant, operational creditor, a business creditor had filed a claim against Flipkart in Bangalore NCLT, and the NCLT rejected that application. So that is where Flipkart was Flipkart stepped out of the clutches of insolvency. If the application is accepted, then as I said, there is a resolution professional who is appointed. He is the court-appointed interim CEO or an interim managing director who works under the supervision of the committee of creditors for the entire 330-day period. The resolution professional not only takes care of the business of the company during this period, but also invites the resolution applicants or the prospective buyers to look at the company, do their due diligences, and submit a bid document which we call resolution plan. Now, this resolution plan, once it is, if there is no resolution plan received in the process, let's say there are companies in which nobody is interested, or if resolution plan is received but is not approved by the committee of creditors or is not approved by the NCLT, then the company goes into liquidation. And then there is a process of liquidation. Within 1 year, you have to liquidate the company and sell off all the assets through a public auction process, if there are any. If the company receives the resolution plan, then the process is the COC, Committee of Creditors, review it. They negotiate the commercial aspects and various other aspects in the resolution plan with the bidder. Whosoever is the H1, the highest bidder in the process, if there are multiple bidders, then they negotiate with, it is their discretion whether they negotiate with everyone, whether they negotiate only with the highest bidder, whether they do a Swiss challenge process, which was commonly adopted under European bankruptcy processes. It is up to their discretion because the underlying objective is to maximize the recovery. Once the H1 is declared pursuant to this process of negotiation, then they will submit the approved resolution plan to the NCLT, and NCLT then approves the resolution plan for the implementation. The resolution applicant then implement and acquire the company and step in as the new promoter, new board of directors, new management of the company. And all the resolution professionals and committee of creditors are retired from that day. From the recovery perspective, whatever amount the resolution applicant offers in the resolution plan, this amount is distributed in the following waterfall mechanism. So if you see, and this is quite important, if you see the bucket number 5, now these buckets are sequential. It's not listed in the serial number. They are sequential. So it's a step waterfall process where you have to first pay the insolvency resolution process cost, which is the cost of the resolution professional or the committee of creditors or any other ancillary costs that are incurred for the first 330 days. Then the secured creditors and the workmen, they are in terms of the lender's basket. They are the first basket that is taken care of. Then you have your employees. So workmen and employee, the basic difference is workmen means the blue collared ones, and employees mean all the white collared ones. The employees is the third basket that they receive their dues. And then the fourth basket is your unsecured financial creditors, your unsecured lenders. And then you have the fifth basket, which is the most important basket. This is for the first time in the regulatory history of this country. The government has taken a step back, and government has actually called themselves in has confined themselves in basket number 5, that after paying up your secured creditors, your employees, your workmen, and even your unsecured creditors, then only if there is anything which is left, then come and pay me. Normally the principle has always been inverse, where the crown debts or the tax dues or the statutory dues, we call them as the first ones to be paid off. Central and state governments have generally been attuned to receive the first cut of the kill. But this is the first time in the country IBC gives them a fifth basket, puts them in the fifth basket after all other commercial creditors or commercial people are taken care of. Then the sixth basket is if there is any other remaining debt which cannot be classified, let's say in any one of these uh, 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 aforesaid 5 baskets. And then you have your preferential shareholders and equity shareholders. This is the overall time chart of the insolvency process. I'll not go into detail. I've already given you the brief snippets of how the insolvency process works. The slide gives you a time chart of within how many days you have to do this, and then subsequently how the entire sequence is drawn up or the step plan is drawn up. But as I said, I've already given you a broad genesis of how the process normally works. I'll not go much into detail into this entire process. A recent amendment has been brought in. It's not actually as recent. I mean, it's now almost a year old, where initially your financial service providers were, were kept out of the insolvency process. Now, who are your financial service providers? Your NBFCs, your banks, your insurance service providers, all of them were kept out of the insolvency process. So you cannot tomorrow go up and stand up and initiate an insolvency against, let's say, a State Bank of India or any other, a mutual fund or an ARC. That is where a classic example, 1.5 year, sorry, 2 years back, ILNFS went into financial doldrums. People understand this difference, that ILNFS, the holding company of that group, is which is an
Hello, Mr. Jain, you're not audible.
Mr. Jain, you're sorry
and
your voice is coming.
because ILNFS is an NBFS, and that is where the central government and appointed a new board, ILNFS, and now that new board is running a so-called. Is it better now?
Yes, much better.
Okay, thank you. So I was giving you an example of ILNFS. Now, ILNFS, being an NBFC, could not have been gone into insolvency, and that is where the central government stepped in under Section 241, 242 of Companies Act. They took over the board of directors of ILNFS and and now the new board of directors is running a so-called disinvestment process of various ILNFS companies and the subsidiaries. So ILNFS process is slightly different than an IBC process, although it is running on the ages or the processes of IBC only. But now what happened a year back was when DHFL started, when DHFL went into financial problems, the government then realized these should be brought under the aegis of IBC, and that is where they introduced that NBFCs having an asset size of more 500 crores, those NBFCs can be pushed into insolvency provided you get a RBI approval for that. So as that is where DHFL now is run under the IBC process and is not running as per the ILNFS mechanism. Going forward, assuming any other NBFC with 500 crores or more asset size faces any financial difficulty, they will also now be tried under insolvency. What is not yet covered is all your mutual funds, your ARCs, your banks, your insurance services. So you have seen Yes Bank, which happened early this year, because it was a bank, could not have been tried under IBC, and that is where Yes Bank was saved outside IBC process under a RBI, and State Bank of India stepped in. The duties and functions of resolution professional, as I said, I've just broadly laid out the whole duties. I'll not go into detail because this is something that is already enshrined under the code. The RP, as I said, is the court-appointed officer who is running the process and is trying to not only run the company in the interim, but also try and find a new buyer. That's the broad outline of something that is already enshrined, said, is the court-appointed officer who is running the process and the code itself. Now, IBC is a mode of acquisition, which is where the most important meat is how you can participate in an IBC process. So you have a company which is in financial stress. You can either buy the company directly through either an NCLT process, which is the IBC process, where you actually bid as a resolution applicant in the by submitting a resolution plan, or you can also do it outside NCLT, where let's say the company is facing issues but is not yet admitted under IBC. So in that process, investing the insolvency process, investing in that company pre-NCLT is also a mechanism that most of the bankers are right now negotiating. We call it a pre-IBC situation, where the bankers try and find a buyer outside the IBC process. They give the promoter some time. 180 days has been prescribed under June 7, 2019 circular of RBI. A 180-day timeline is given the banks, where the promoters are given an opportunity to either provide more money to retain the loan, or bring in a white knight themselves and save their company. In case of also sometimes on this process, where the bankers try and find a white knight who can acquire the company, pay up the bankers. So the bankers then assist or facilitate the change of management process. We also call it a hostile takeover under the takeover code. So this is akin to a hostile takeover, where the bankers try and assist the incoming acquirer in helping and acquiring the company. There are also ways and means in which the bankers can sell their loans. So most of the bankers do this process. In fact, most of you have gone through the recent RBI draft paper, which RBI has released on transfer of good loans and standard loans and stressed loans. That is the route which RBI follows. Till now, the banks can sell their stressed loans to the ARC. So an investor wanted to acquire loans can invest in an ARC or participate through an ARC. And we have multiple examples, like SSG does this with Acre, or you have Avenue Asia investing through RSIL. Now, these are some of the examples where some large private equity funds use acquiring the loans through the ARC route. And then the last point is indirect way of acquisition, NBFC, or you acquire a bank, and that bank or that NBFC, the entire stressed asset exposure of that bank or the NBFC goes to the acquirer. So that is where, let's say, a DHFL processes, or that is where, let's say, many other L&T finance processes. Most of the other processes are running under this way of process, where there is an opportunity to invest indirectly by acquiring the lender or investing in the lender. Whenever a resolution applicant steps in to acquire a company, these are the three broad due diligences that they do. I'll not go into detail about these due diligences. These are case specific. You have to do a financial, tax, and legal. I mean, it's not rocket science. Everybody does that in any transaction. I think the bottom line that I wanted to highlight here is that the whole purpose of doing a due diligence in an insolvency process, which is different than a normal routine M&A transaction, is that in a normal routine M&A, you have a willing buyer and willing seller, and the buyer asks for certain indemnities or certain reps and warranties, or there are certain conditions precedent to a particular transaction, which we normally try and bring out through our due diligence. there a buyer, there is a seller who's providing amenities to the buyer. Unfortunately, in IBC, there is no such willing seller on the other side. The banks, who are the committee of creditors or the resolution professional, they never agree, or they will statutorily. There is a buyer, there is a seller. Unfortunately, in IBC, they agree, or they will statutorily. Unfortunately, in IBC, there is no such appointed by the court, so he or she will never be able to give you a rep or a warranty. The lenders, on the other hand, treat this for all practical purposes as a mode of recovery, and they will never agree for any indemnification to the buyer. And that is where these due diligences become a lot more important as compared to a M&A transaction. That when you draft your resolution plan, you put all your, let's say, issues that you have highlighted out of your due diligences as the reliefs and concessions that you require the NCLTs to allow. So because IBC is a statute, because a resolution plan is approved under a statute, it does give you a statutory color to the acquisition that you are doing. If you put all these reliefs and concessions or the requirements of an acquisition under that resolution plan, and those requirements are approved by the COC and then subsequently by the NCLT, those reliefs and concessions does give you some amount of legal or a statutory cover. Not all, it's not 100% foolproof mechanism, specifically when you're dealing with a complex country like India, where you have a federal structure of doing something else. IBC is a central statute for all practical purposes. So getting it implemented under the state statutes or state laws or state regulators agreeing for those reliefs and concessions is very difficult. But at least if it is there in the resolution plan, it does give you a huge advantage over all future liabilities. Just to give you an example, specifically from a tax perspective, if there are assessments which are due, which have not yet happened, and if you acquire a company today, and the assessments are underway for that company, either with the income tax or with the, let's say, indirect tax assessments. If the assessment order comes against the company after your acquisition, then is that a cost that the new buyer has to pay? Because that cost or that amount was never even known at the time of due diligences. The answer is, if it is provided in your resolution plan, in the reliefs and concessions, then NCLTs and Supreme Courts have done this, have looked at it favorably, that you knew the risk and you had adequately provided for that risk in your relief and concession. If it is not there, then that is a challenge. So that is where drafting of your resolution plan is a very important task. This is a broad process in which you apply to, in a CIRP process, you submit your expression of interest, then you conduct your due diligences, you prepare and submit your resolution plan, you negotiate with the COC, and if there are any approvals, let's say CCI approval, for example, is required, if the combination regulations are triggered, then you take the CCI. Part is in CCI specifically, there are fast track cases almost on a weekly basis and sometimes even twice a week. Their committee sits and looks at and approves the matters which are under IBC. So the process is fairly simple. These are some of the benefits for a resolution applicant that you get if you acquire a company from IBC. And these are some of the issues that you need to keep in mind. Otherwise, IBC for all practical purposes is almost equivalent to a M&A transaction. You get a clean asset. All your past liabilities are wiped clean. You need to take care of your litigations, though. If there are pending litigations at different forums, then you need to take a view on those litigations and probably factor that in your acquisition cost. Otherwise, for all other known and unknown liabilities, if it is adequately provided in your resolution plan, as I had mentioned a while back, you get a clean asset. There are no additional approvals that are required. It's IBC for all practical purposes a single window clearance. So no shareholder, no corporate, no SEBI, stock exchange approval. If it's a listed company, all your delisting, takeover code, etc., is exempted. In fact, recently, in takeover code or in ICBR regulations, your pricing guidelines also do not apply on listed company acquisitions through IBC. You can also raise your ECB money to repay rupee loans, which is otherwise not allowed under normal acquisitions or normal refinancing. And it is binding on all regulators, except, as I said, for state government, we do have experiences of struggling getting state governments on board or state regulators on board. For example, mining regulators, they all are state regulators. So getting them on board is a difficult task. But it is the central regulators, all of them are on board. Classic example, Aircel being acquired by UVARC. Aircel had the spectrum, the 2G license, and that spectrum, DOT stepped in and said, no, you have to take my approval also in addition to the IBC approval. The court said nothing doing. IBC is a single window, is one sole encompassing law. Even DOT approval is, even IBC is binding on DOT. So DOT will not be required to give any additional approval, and the spectrum license can easily be transferred from ASL to UVRC, and that has happened. Some judicial precedents, I'll not go into detail, but one is there were cases that whether the commercial negotiations that the COC does the NCLT have the power to challenge those commercial negotiations also? I think the Supreme Court has already upheld that the commercial wisdom of COC is supreme, and NCLTs cannot go down that path of negotiating commercially. What they can only do is they can look at the process, and if the process is not followed properly, then they can challenge it. Otherwise, commercial wisdom is upheld. The CIP timeline I've already mentioned in my introductory paragraph, 330 days, while it's sacrosanct for all except exceptional circumstances. The other one is 29A. Now, this is an important piece which I have not mentioned in the resolution process. The promoters cannot make an application to acquire their own company under the IBC. There is a specific section, section 29A, which debars a certain category of individuals or entities, and that ineligibility basically means that the promoters cannot get their company back at probably 1/10 of the price. They are ineligible, and not only then ineligible under IBC, even for future acquisitions or future government bidding, etc. Now, this is a norm that you are, if you are disqualified under section 29A of IBC, you are effectively disqualified across the board. This is somehow similar to section 174 of Companies Act, where a director disqualified under Companies Act cannot be appointed as a director or officer of repute in any other organization or any other government bids at least. That is the similar color that even 29A has got under IBC. Another one is where the resolution plan is approved, the amount which is receivable by the corporate debtor shall continue to remain with it, which means that if there are amounts which are supposed to be recovered, those amounts can be factored in by the incoming acquirer. They can say that just because I've acquired the company in IBC and there are certain recoveries, that does not mean by the corporate debtor, that does not mean that the recovery has to be set off or has to be transferred to the lenders. I can very well avail the benefit of those recoveries. So that is an important judgment that came out in the Vardhan Industries matter. Some of the other key judicial precedents are listed in the slide. I'll not go on each and every one of them. Just highlight one or two. As I said, one is the conditionalities. It is a normal feature of an IBC that you cannot submit a conditional plan. You have to submit a definitive plan. But in certain exceptional cases, NCLTs have gone ahead and approved a conditional resolution plan. So you need that is where your due diligence becomes utmost important. That what are the deal breaker issues, and if they are so pressing that cannot be factored in either in the acquisition cost or in, let's say, it is out of the control of the buyer, then they can submit a conditional resolution. Another important feature, your IBC cannot be, you can initiate IBC not only against the corporate debtor, which is the company, but also against the guarantors simultaneously. So if you have company structures of company versus a guarantor, both of them are companies. It's not necessary that you have to first settle the claim with the corporate debtor, and then only subsequently you can move to the corporate guarantor. You can actually run the process simultaneously for both. The last point in my slide is some of the recent reliefs that have been issued by RBI and the regulators on the stressed assets. Now, this slide gives you a bird's eye view on the RBI's prudential framework, which RBI came up with. This helps you understand what are the various classification norms and how the resolution plan which is implemented can be implemented in a time-bound manner. The purpose of this stressed assets would be to recognize them, to report them, and to find a time-bound resolution. And there you can get, as I said, the promoters do get a 180-day period to try and resolve the insolvency or the resolution within that period. If they are unable to, then it is up to the discretion of the lenders. If they still want to give some more time to the promoters, they have to do additional provisioning in their books. But otherwise, if beyond 180 days, in most of the cases, the insolvency is kicked in and the matter goes to the NCLT under IBC process. Some recent announcements that have come in under the COVID-19 during this period. Some of them were a part of the Atmanirbhar Bharat made the FM, and the subsequent announcements made by the RBI governor is that the term loan have been rescheduled. There's a moratorium which has been allowed for 3 + 3 6 months. The working capital financing has been eased out, and the lenders have been allowed to recalculate the drawing power by reducing the margins or reassessing the working capital. The SMA and the NPA norms are also amended to an extent that moratorium, whatever defaults that have happened, let's say during the moratorium period, they will not be considered or taken into account while classifying the account as an SMA or an NPA. The most important one is the ordinance which came out early last month, where the IBC got suspended for a period of 6 months and can be extended, let's say, for another 6 months, which says that from 25th March 2020 till 25th September 2020, which is a 6-month period, if there is any default, then the lenders cannot invoke IBC for those defaults during this period. The government effectively has said that the 6-month period is the COVID period, and within this COVID period, if there are any defaults of your EMIs or your repayments, you cannot initiate CIRP because it is presumed that the default is not because of, let's say, the bad intention of the promoter or malafide of the promoter or the company, but because of the pressures, market pressures, or the business issues arose out of COVID. So this is how the entire understanding of the IBC code has been. And similarly, if there is any decision which is taken by the promoter, and let's say that decision was taken in the best interest of the company, but somehow because the times have changed, because of COVID, the market has impacted. So those decisions cannot be challenged subsequently, and the forensic auditors will not, or the banks will not basically say that this was emanated out of a malafide intention of the promoter. That takes me to the last piece of my presentation, which is effectively, I'll conclude on this part, and I'm happy to take any questions as you may have on this particular piece.
Thank you, Mr. Jain, for making such a detailed presentation. We have with us in the panel two eminent faculties of Amity International Business Schools, Mr. Professor Ashu Jain and Dr. Namita Sahai with us. And I would now throw the session open for question and answers, and to our panelists for taking up the questions which have been asked by many of our students from across Amity institutions in India and the world.
Thank you, Gaurav. Thank you, Mr. Jain, for a wonderful presentation and an insight into the insolvency and bankruptcy code. And I do understand it, it is one of the biggest structural reforms which the government has introduced. And NPA is a topic which is very, very important, I think, right from the time in 1991 when the Narasimhan Committee had, talked about it. So it's almost 3 decades, we are struggling with this NPAs. And, in your earlier slides, I've seen that, you have pointed out all the efforts which the government has taken, whether it is a CDR, or it is the SDR, or it is the, SARFAESI Act or anything. So indeed, I think it's a long battle which the government is really fighting. And, so just because the time is a little short, so there are a lot of questions which have come from the students. So I like to combine a few questions and, just want to ask you on a very different dimension altogether. My first point is that when you're talking of the stressed assets, we understand that NPAs are not only created, of course, you did talk about the financial stress which has led to the creation of the NPAs. But we also know that, and I think most of us can really understand when we are reading the newspapers that the case of willful defaulters. So a lot of NPAs, when we talk of Malia, Vijay Malia, to the tune of 9,000 crores that, with he's taken, and then the Nirav Modi case and all these cases. And this word, which is a very, very common word, we talk of crony capitalism, the nexus between the private sector and the bankers, the government. So, like, what is the IBC is something which can really work, when the person who wants to get the thing resolved goes to the, applies. But what is the, what is the way out for the willful defaulters? This is my first question. My second question is, regarding when you're talking about the stressed assets. Now, the question is that, when finally a company, the signals of the stress start coming into the company from very, early itself. And seeing the ILNFS case, when, bonds which were issued by ILNFS were all AAA rated, and suddenly overnight they became junk bonds. So, what kind of, I think it is time, I just want your insight on that, inputs on that, why are we, of course, credit rating agencies are not reliable anymore, but why is the banking system and not using more, advanced models to identify the stress? Like, of course, one model which I want to talk about is a very old model, that's also an debt score, which started in 1968. So, I remember one of the speakers talking about that, if not going by the credit ratings, but if this score has been worked out for even ILNFS, we could have understood that this company is under great stress. Now, continuing with that question, we are in this age of artificial intelligence. So, we have neural networks, we have so many artificial, intelligence techniques. So why are we not, applying them? Why are we waiting that, a company becomes, an asset becomes a non-performing asset, it becomes a stressed asset, then it goes for resolution? Why not nip the evil in the bud? Why not apply these, so this is my second question. So what are the way out? Then the third important question, which is, also coming from the students, is about the role of the ARCs, the asset reconstruction companies. So we are, I think way back, one of the resolution process, 14 ARCs have come into existence. And also in 2017, and the Deputy Governor of RBI, Mr. Viral Acharya, he also talked about, public ARCs, private ARCs. So why couldn't we make, the ARCs efficient? Why could we not make them, the asset reconstruction companies, efficient? Right. So this is the third and the last question, which I wanted to ask you is about the, the bad banks. Right. So Mr. Sunil, in the beginning also, Mr. Rahul talked about the new thing which is coming up, it's given by the economic survey. And of course, it is being even proposed by, a lot of people, the professionals that, why doesn't RBI, why do we not go for a bad bank? And with the moratorium, that you're giving, and we have the NPAs almost at the tune of 9.7 lakh crore, and we expect another 5.5 lakh crore to go up with this moratorium. So is IBC, will be in a position to handle everything? We are in a bad shape. 3 decades we are struggling with the NPAs, and still, I hope I get my question across to you. So, but can you just throw light on these couple of points? One about this willful defaulters, the crony capitalism. Yep. Then the second is about, that how to identify the stress in the assets early itself, how artificial intelligence, how, new procedures, technology can be employed before. Third is about this proposal which has come about the bad banks. And then, of course, the Sunil Mehta committee, under the chairmanship of the chairman of Punjab National Bank, which has also brought up some resolutions. So, in the light of these points and questions, if you could just throw some inputs on that.
Sure, Dr. Sai. Thank you for the questions. I'll take them one by one. As far as the willful defaulter question is concerned, yes, you are correct. I mean, the issues of economic offenders, fugitives, etc., is a burning issue. more than I think the amount involved. I think it is more of an optical issue that brings a lot of a loss to the credibility of the country and the banking system which operates within the country. I think that is being handled right now as we speak in the processes by various agencies collectively. But your this particular question is actually linked to your second question, which is early signs of stress. Why couldn't the banks understand a Nirav Modi was in the making, or why couldn't the banks know that Vijay Mallya is over working on its balance sheet, and the banks kept on lending, and that is where they piled up almost 9,000 plus crores of the loan in the banking system, which effectively then failed. So why couldn't the banks know that? On a personal front, I think from a willful defaulter perspective, that has already been taken care of under Section 29A of IBC. At least first time in the country, economic offender, a willful defaulter, and there are various other categories under 29A, cannot now restart their businesses. At least there is an economic sanction on these people, and whether at least under the government processes, they cannot participate in the government bids or any acquisitions in future. So to that extent, the government is trying to control that particular aspect. But from an institutional perspective, I think the lenders have started using various tools, various mechanisms. I personally have made multiple presentations to large bankers and NBFCs where there are some fantastic tools that have been developed by various professionals and various agencies, and the bankers have started now realizing the importance of those tools. Some private NBFCs and private institutions have already started implementing those tools in their day-to-day MIS, as we call them, and they are now doing cash flow monitoring, liquidity management, in order to ensure that all these stress can be detected early in the life of the company and remedial actions can be taken. So that at least is a good thing that has happened, at least from a private perspective. I am yet to see a large public sector bank adopting these methodologies. I know for sure, and I'm a part of some of those discussions at the RBI level also, that these are being talked about and are being taken very seriously. There is a generational shift in the mindset of the bankers and the regulators, and they now realize the importance of it. I think it's just a matter of time that even government banks, or PSU banks as we call them, will also start adopting these technologies, as the private NBFCs and banks are already doing it. The third point is on the role of ARCs. Now, the role of ARC, yes, it is important. I think what has happened is, and I'm purely explaining this from my personal experience. ARC, while the idea has been a novel concept that ARC should step in to restructure or reconstitute the loans and try and find resolutions, unfortunately, ARCs in past couple of years have simply become a route of buying out stressed loans and recovering those loans and earning returns by the investors. While it is on a commercial front, it is not. There is absolutely no issues. I mean, anybody invests money has the right to earn returns on it. But in the process, what has happened is that the ARCs are now only looking at good loans or loans which have the capability of being recovered, and they are not looking at other loans for the perspective of resolving them. They're only looking at with the perspective of recovering a higher return out of those. And that is where RBI realized this problem, and RBI is now opening up the entire debt market or the bond market as we know them, which is already there in some of the large developed countries or economies. RBI is now shaping up a similar structure for India, and that is where I had mentioned in my presentation that RBI released this draft working paper, the comments for which were invited from public. 30th June was the last date, and we are a part of those discussions with RBI, where RBI is trying to provide a robust debt trading market in the country in order to ensure that these anomalies or these inefficiencies in the existing NBFCs, ARCs structures can be ironed out, and you have a much larger professional set of investors who can help bring this sea change in the entire industry. Moving on to the last point, which is the bad bank point. Now, this has been, yes, a hot topic for discussions for quite some time. especially in last 2 or 3 years. Post demonetization, we have been hearing a lot about bad banks. I can tell you from my personal experience, while I may not be able to divulge much, but yes, the process is underway. The only challenge I think which the government is trying to figure out, or the answer that the government is trying to figure out, is should they give one catch-all resolution for all the bad loans by helping all the banks across the board to push all their bad loans into a bad bank, or should they ask the bankers to take a commercial call first, try and resolve the bad loans first at their end, and if they're not able to do that, then only let bad bank become the second resort for them. So that is, I think, the commercial disconnect or the commercial consideration where the government is struggling to find an answer with, because
Hello.
it should not possibly happen that almost all suddenly are absolved of all their past misdeeds, or and the government is trying to strike a fine balance between what should the bad bank do, and we are very close to that solution. I think it's just a matter of time. You will hear something very soon on this concept, whether it will be exactly a bad bank as we normally know it from the US or the European markets, or will it be, I would say, an Indianized version of a bad bank. I think that is something that a time will tell, but something of that sort will surely come in some time.
Thank you so much. Thank you. Very good. Well answered. And any other question, Gaurav?
I think I'll just pass it on to Professor Ashu Jain for the last question due to the paucity of time. So, Professor Jain, if you can please go ahead.
Thank you very much, Mr. Anshu Jain. I'm Dr. Ashu Jain. First of all, I would like to convey that it was a very insightful and fruitful session. My compliments for you. You have a long as well as rich experience in different financial activities, and you have given a great thought to our students about stressed assets resolution. Thank you very much. Although we are running short of time, but just one quick observation and then one quick question also. I can recall that exactly 1 year ago, RBI, they issued a prudential framework for the resolution of stressed assets, which gives lenders 30 days time to review the borrower's account before labeling it as stressed asset. And in this way, this is just an example. In this way, RBI has issued revised norms, multiple revised norms to deal with stressed assets. But this is also a fact that stressed assets have been rising rapidly in India. A number of factors can be identified, like global slowdown, governance related issues, misconduct, political factors, and many more. Now, the only one question from you is, what remains the role of financial management professionals and experts like you in tackling not only the stock of stressed assets, but also the rising flow of further bad assets, bad loans, or stressed assets? Please.
So I think I have partly answered this, Professor Jain, when I was answering Dr. Sahai. I think professionals like us, while the bankers, the lenders are waking up to the needs of liquidity management, cash flow management, and how to detect early signs of the stress. Financial professionals like us are not only helping banks or the lenders in these processes and are helping them identify those issues and also resolve them in order to ensure that the companies do not land up into insolvency. But in case that happens, then, and you had rightly mentioned about the June 7, 2019 circular of RBI. Now that circular does allow a pre-IBC window of 180 days. That pre-IBC window of 180 days helps companies, promoters, and financial professionals like us assist companies in doing a debt restructuring, identify what is doable and what is not doable, what loan can be converted into equity, or how much loan can be survived as a loan and can be serviced by the company. These are some of the examples that professionals like us do. We not only provide our financial acumen, but also help the companies with our legal and the technical aspects, and try and help them in tiding over these entire debt restructuring processes to ensure that they do not fall within the trap of IBC. If they do, then we help the lenders make the best use of IBC and try and maximize their value. And on the other hand, we assist resolution applicants in identifying good assets, which probably are under IBC because of either management issues or any other external factors, and help them revive and restructure and provide a valued input in acquiring those assets. So I think from a professional perspective, financial professionals perspective, the scope is very, very wide. And it is just a tip of the iceberg, if I may say that. It's only 2.5, 3 years. The law itself is in a very nascent stage, and a lot of professionalism, a lot of development, and a lot of growth is required vis-a-vis the financial industry. And financial professionals will have a lot of scope in catering to these demands, which will only grow from here.
Thank you, Mr. Jain. More questions are pouring in, but due to the paucity of the time, we will have to conclude this session now. The session number 2 in the webinar series, Amity PwC webinars. And thank you for such an insightful and a detailed presentation. Bankruptcy and insolvency laws in markets like US and other developed countries have been around for many decades and have been standing on very firm grounds. It is time that India also gets firm laws, and the interest of the creditors, the interest of the shareholders, the interest of the entire stakeholders are also protected as we go along. So thank you very much once again on speaking on this topic and for a very detailed presentation. And I also thank my co-panelists, Professor Ashu Jain and Dr. Sahai, on the session for asking the questions from their experience and from some of the students and the faculty members have asked. And thanks to the entire IT team for making this possible.
Thank you, Gaurav. Thank you so much.
Thank you. Thank you, everyone.